So let me pass out the note packet to you guys. This is the officially judicial branch, Supreme Court. Probably the smallest, or one of the smallest sections of this the Constitution. But keeping in mind without the Supreme Court, and this kind of goes back to the whole Alexander Hamilton and John Jay and John Adams talking about how if we didn't have the court system, then who would we have to argue our points to, right? We'd have to somehow change the laws over and over and over again. So there'd be nobody interpreting the laws. And that actually goes with one of our definitions. But regardless, when we look at the Supreme Court, we're looking at Article 3 of the Constitution. The U.S. Supreme Court is the only court that is actually created by the Constitution. All the other courts that we have are created by Congress. They were the ones that actually created it. All the smaller courts after that. Right? So the judicial power of the United States shall be vested in. You guys see that there's a glare. Yeah. Yeah. Okay. So the judicial power of the United States shall be vested in one Supreme Court, and such inferior courts as the Congress may from time to time ordain and establish. So again, Congress creates all the lower courts. So we do have a federal branch in Cleveland, Ohio, created by Congress. Wasn't there? The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior. This is kind of one of those interesting little twists to qualifications. Like for the president of the United States, you have to be a certain age. You have to live in the states for a certain amount of time. You have to be a national citizen. For the representatives, you have to be a certain age. For the districts, and if the citizen, of course. But, and then you have to have been a citizen for a certain amount of years. Right? So for this situation, though, all they ask for is good behavior. And there's really no definition as to what good behavior is. It could be lots of different things. Most judges, if you have some sort of federal offense, one, you wouldn't be going into that field anyway, the offenses or criminal cases. But regardless, I could, if I really wanted to, if I was president of the United States, I could nominate one of you guys, if I so choose. Now, do I get to pick free and clear all of my judges? Or does the Senate get a chance to say yes or no to those appointments? So that's that check that we talked about last section. So yes, I could pick anyone I want to, but you guys would be going in front of the Senate. And the past 2 years, there has been, if you go to YouTube and look up any of the Supreme Court justices or federal judges, they've been asking to put on the courts. Question after question after question after question. A lot of them now recently regarding critical race theory, what's your stance on abortion, what's your stance on this, what do you believe is this. The new one that just happened a couple months ago was the Attorney General putting a memorandum out saying that potential domestic terrorists are now looking at some parents at school board meetings. And so, of course, the question now is becoming, do I, as a judge, how would you deal with a parent being brought to you in front of a judge in front of you for a federal crime of domestic terrorism because of this school board situation? Right? So, well, I get to interview. So Senate gets to pick and choose and say yes or no. Right, so good behavior is typically what we're looking at. Next one. Congress has the authority to create and determine the number of justices on the court. This is what we're dealing with right now. There's actually a push because the current court has more conservative or judicial restraint justices, there is a push by the Democrats because they control Congress and the presidency to add 3 more or 4 more positions. So if they add 3 more positions or 4 more positions, which they can, then they can place on the court people that are sympathetic to their more judicial activists, people that tend to stretch the law a little beyond what the original intent is. There is no age limit. There is no residency requirement. There's nothing other than good behavior. So when you look at the Supreme Court or federal judges, they can serve for life. What is a potential drawback or a negative to serving for life when it comes to being a judge? Let me go in the direction. If you guys were elected to your judgeships and you only had 6 years to serve, what's the positive for having a 6-year term? What do you have to do as a judge in that 6 years? What's what you think? You're a judge. You only get to serve for 6 years. What's good about having a 6-year limit? Keep in mind you're elected to that position, right? So you only have a certain amount of time. Would you potentially want to be reelected in that position? Most people do. So what would you have to do during those 6 years to get reelected as a judge? Do you want to tick off the people that are voting for you, or do you want them to be happy? Be happy. I want them to be happy. I want them to like my decisions, right? So I want to keep criminals in jail. I want to listen to my constituents and kind of do what I think that's best for my constituents. And at the end of 6 years, if they like me, great. I get to be reelected and they'll put me back in office for another 6 years. Now, let's switch it and say you're serving for life. Do I have to worry about my constituents? No, I'm in for life. I don't have to worry about anybody. What is my sole focus supposed to be if I'm a judge then? I serve for life. It's the only thing that drives me when I make my decisions. It's not about making my constituents happy, because it's not about them. What is it about? You're a judge. You ever watch a TV show or movie, you watch the judge, what are they beholden to? What do they have to follow? Who in here has ever gone over the speed limit? Whether you've caught or not, what have you broken? The law. Good. Let me go back to my original question. What is the judge who serves for life beholden to? He or she only has to worry about what? The law. That's it, right? So if I have the Constitution in front of the judge and I'm serving for life, I don't care about the people that are in my state because it doesn't matter. I'm serving for life. Unless I do something really stupid like number 4, I get to serve for life. So when I'm making my decisions, the only thing I'm worried about is it legal or is it illegal? That's it. And if you don't like my response, that's okay, because I'm here for life anyways. Now, if I do something really, really bad, then in a federal position, Supreme Court or federal judges, I could be impeached and kicked out of office. So that does happen. It has happened. Matter of fact, with the notes a little bit later on, there's like a checklist of some people that were kicked out of federal positions. But I just get to do my job. Right? They're just focused on law, which is why, is there any speed behind them making decisions at the Supreme Court or federal level? Not typically. And that's why when the Supreme Court gets cases, they get them in October, November, December, and they don't make the rulings until May, June, July. So they got plenty of time. You want to come to the Supreme Court? Good. It's going to be 5 months from now. You bring your case for the Supreme Court because there's no speedy trial. You don't have to worry about speedy trial because these are appeals. They eventually get to the Supreme Court. So 6 months from now, we have to have our case ready and we have to present to the Supreme Court justice. The other thing that you'll find too, if you ever follow up on politics, is some of the Supreme Court justices, like Clarence Thomas, who's one of the oldest guys on there, he doesn't ask questions. By the time people are arguing their points to him, he has read so many legal forms and so many laws and so many things. He's already kind of made up his mind. But he goes, of course, sits at the court for people to talk to him. But he never typically asks questions. He just lets them talk and sees that they can try to change his mind. So, there we go. First clause. Judicial power shall extend to all cases in law of equity arising in the Constitution. So, the law of the United States, treaties made, shall be made under their authority. Law case affecting ambassadors, public ministers, consuls, anything deal with the United States will come to the Supreme Court. So we talk about original jurisdiction. Between a state and citizens of another state. So if I'm suing between the states, that goes right to the Supreme Court. Between citizens of different states, Supreme Court. Between citizens of the same state claiming land under grants for different states. These are all kind of like the things that will bring it right to the Supreme Court on a more immediate. So if let's say that you guys are ambassadors over in Japan and something happens that's potentially illegal, the Supreme Court of the United States will hear that case right now because they got to make sure it's legal or illegal in the U.S. Or let me rephrase that. Let's say that there's a Japanese ambassador in the U.S. Goes right to the Supreme Court. So there's an original jurisdiction. Exclusive jurisdiction or original jurisdiction, trial of a person charged with a federal crime. If there's a federal crime, it will go right into the federal court system. Now it starts at the lower levels and then moves its way up. Some of those cases, President Biden has had this happen to him already. President Trump had it happen to him. President Obama had it happen to him. So they sign or pass executive orders. And the Supreme Court will jump in and say, nope, that's illegal. Or yes, that's legal. So immediately goes to them. During the whole election process last fall, there was 3 or 4 things that were sent to the Supreme Court from the states saying, hey, this looks illegal to us. Can we look at this? And tell us if we think this is legal or illegal. That's exclusive. A lawsuit involving infringement of a patent or copyright is direct or exclusive to a federal court. And then if there's an act of Congress, something that they do, that they passed, that someone can sue them for. So let's say this OSHA thing goes through with President Biden regarding the 100 or over employees have to get vaccinated, those companies. I guarantee the very first day that goes into effect, a company is going to sue over this act. This actually an executive act. But if the Congress were to pass that, then someone could sue right away and say, no, this is illegal, and it would go right to the Supreme Court. Concurrent jurisdiction, these are things that are both state and local or state and federal that could, usually it will get appealed from state to federal. You don't typically go federal to state. So you typically see at the state, person goes to the federal court. The 2 people you guys hear in this, the plaintiff and the defendant, if you guys are ever looking at the cases that says Texas v. Arizona or Texas v. Johnson, right? The first person in that is always the plaintiff. So and so is suing so and so. New Jersey versus TLO. New Jersey is the plaintiff versus TLO, the defendant. So you typically have it in that order. The defendant is the person being accused of the crime. This is the person who has to defend themselves. So that's the phrase defend themselves. So for this one, look at different scenarios. Citizen M robs a bank in California. This is a federal offense because robbery violates federal law. Right, regardless, because it was a federally insured bank, FDIC insurance, because the economics with me, FDIC. A lot of the banks now, if it's let's say it's the bank, Medina County. There's one that's on 18 over by yours truly. So it's a county bank. It's not a federally protected bank. That would be a county. Then we could go right to the county. But if it's federally insured, the federal government has protections over it. It's a federal crime. Michigan sues Citizen Y from Massachusetts for damage. Concurrent. This one would probably start in the States, and if it had to, it would move up the court system. And then Citizen Z of Ohio has her car repaired at AJ's, the local repair shop. The car breaks down on her way home. She sues a repair shop for breach of contract. That is a state issue. Has there ever heard of the lemon law? We have it in Ohio. Lemon law. If you buy something from a dealership and it's like failing like right away and it has all sorts of issues, and the tires go flat, and the oil is leaking after you buy it, you can sue over lemon law. And they say basically they sold you a lemon, and the company has to take it back and give you full value. My brother should do that a couple years ago. The truck that like day 2 or day 3, tires, oil change. It was like, dude, sue lemon law. You can even go in and say, I'm going to sue you over lemon law. And a lot of them go, oh, no, we'll take it back. So the other thing I mentioned earlier was original jurisdiction versus appellate jurisdiction. Original, there are things that go right through the Supreme Court to that level. Appellate is the one we typically hear all the time. So any of the court cases that are hitting the Supreme Court right now have been appealed from the lower level to the mid level to the upper level. So. Okay, so this one right here is original versus appellate.
Former NFL star O.J. Simpson charged with his ex-wife's murder. And again, it was the trial of the century.
It's the law of the land, and the land where nothing is more important than the law.
But the debate over Bush v. Gore goes on to this day, not least among some of the justices themselves.
Welcome to WatchMojo.com, and today we're counting down our picks for the top 10 court cases that changed America.
The Supreme Court in 1824 provided an answer within the framework of the case known as Gibbons versus Ogden, or more simply, the Steamboat case.
For this list, we're looking at court rulings from the United States that had a significant historical impact in shaping the country that exists today. Now please take your seats. Court is now in session.
Court has just ruled part of that law is unconstitutional. This is being described immediately now as a big win for advocates of gay rights.
Number 10, Bush v. Gore.
For the last 80 years, the Florida court has always ruled that the right to participate in the democratic process is more important than a voter's ability to follow instructions.
The 2000 U.S. presidential election resulted in one of the most controversial and divisive legal decisions in the nation's history. In Florida, the vote was deemed too close to call, and the Florida Supreme Court called for a recount. But the United States
Sorry, I wanted to show you that because this is important.
too close to call, and the Florida
All right, so this was the ballot in Florida. This is back pre-digital, all the stuff that you guys will have when you guys go vote. You literally had a little pin, a push pin. You would poke into a little card, and it would pop a little. They called them chads out of this little card, and you take the card, and the computer would count the card holes. But if you look at the top left, number 3 up there, George H. Bush and Dick Cheney, and then right below that is Al Gore and Joe Lieberman. But if you look over at number 4, see Pat Buchanan, Izola Foster. So if you just remember that clip that the guy just said, the actor in that show, what he said was essentially, all we want to do is provide you a place to vote. We don't have to give you the instructions on, like, if you're not smart enough to research it or know how to vote, that's not our fault. So anyways, Pat Buchanan was getting tons and tons of votes in Florida, and they couldn't figure out why. All the other states, he was like barely doing anything. But in Florida, he had a large percentage of votes. And then they realized people who were voting for Al Gore were punching the wrong hole because they saw the second one down was Al Gore. So they were all punching this hole right here, thinking this one was George Bush and this one was for Al Gore, not looking at the arrow that pointed to that hole. So they counted the ballots. Like it was video. I remember watching video of people actually counting the ballots with lights, like going back and looking and seeing if they had dimpled chads or hanging. It was all crazy. The Supreme Court ended up finding in favor of Bush and said, no, counts are done.
The Supreme Court called for a recount, but the United States Supreme Court overturned the order and sided in favor of George W. Bush, effectively declaring him the next president, which caused concern for many critics who believed the court had overstepped.
The standard is whether or not the intent of the voter is reflected by the ballot.
Gore lost with grace, but after the events of 9/11 and the War on Terror, many wondered what would have been in store for America had the court decided differently.
But the debate over Bush v. Gore goes on to this day, not least among some of the justices themselves.
Number 9. Obergefell v. Hodges.
Now, gay marriage is back at the court, and this time it deals with if states have to recognize their legality.
While many countries around the world have embraced same-sex marriage for years, it wasn't until 2015 that the U.S. Supreme Court legalized the right of people of the same sex to marry, making it a fundamental one.
There was a glimmer of hope among the advocates for same-sex marriage under the law that Chief Justice Roberts might find his own path.
Named after James Obergefell, a man who sought to have his marriage to another man recognized in Ohio, the Supreme Court ruled in a 5-4 split that same-sex marriage was legal under the Constitution's 14th Amendment. Citing the amendment's due process and equal protection clauses, the case overturned the 1971 ruling against same-sex marriage in Baker v. Nelson.
In 1970, they'd applied in Hennepin County, but were turned down in a case that eventually went to the state Supreme Court, where they lost.
Number 8. Marbury v. Madison.
Literally, the last day of Adams' presidency, he was busy signing commissions for these federal judges.
This case was of vital importance to American history, as it declared that the U.S. Supreme Court had the authority to overturn laws made by Congress, and, perhaps more significantly, awarded it the power to interpret and lay down the law.
The upshot of the case was that Chief Justice John Marshall ruled that the court had the power to review, uphold, and strike down executive actions pursuant to the Judiciary Act of 1789. And in doing this,
Marbury, who had brought forth a case petitioning for the court to force the Secretary of State to the decisions, and therefore would not.
They never received their commissions. The Supreme Court.
Citizens United v. Federal Election Commission.
Vote for this guy!
Vote for this guy.
Aren't you tired of this stuff? Acknowledging the disproportionate influence that corporate money can play in the outcome of political campaigns.
For the sake of time, I'm not going to watch the whole thing. But the idea is there are court case after court case. Some are original, meaning the government has the ability to see them right away. which was kind of like the Al Gore one with via Bush. It went right to Supreme Court of Florida. Florida Supreme Court tried to send it to federal Supreme Court. The federal Supreme Court said, no, we're not going to hear it. So you have different variations. Original jurisdiction, state versus state, foreign dignitaries. So I mentioned that earlier. Then we look at the court case. So the case has been ruled on at a lower court and appealed to a higher court. They're not. So the case itself isn't retried. It's whether the case itself has a legal issue. So the case is over. It's done. What we're worried about is, did they use the law according to what it was supposed to be used? So let's say that I arrest. Trying to think of a situation. Say Michaela is driving down the road, and I'm the police officer, and I arrest her, and I read her rights in English and Spanish. And we get to trial and find her guilty, and she appeals it and says, wait a second, yes, I know that I was found guilty, but I speak French. I don't speak English, nor do I speak Spanish. So I didn't realize that was what was being said. So all these things I said in front of the police shouldn't be used in court. Right now, she can prove that to the court. So the case is over. She lost the case. What she wants to find out, though, is the application of that law. Right? So that's the appellate one. And we can go all the way up. And sometimes it gets to the state level and it's done, or you get to the federal district level and it's done. So this is where we get into those decisions. This was a tricky one for the word usage in your vocab. So the opinion itself, keep in mind, anything Supreme Court comes out with is just that. It's an opinion. So I mentioned this for you, Roe v. Wade. Then there was a Casey v. Planned Parenthood v. Casey. Yeah. So all of this we're looking at, these are opinions. They can change. So give it some time in a court case, the Obergefell case regarding gay marriage. Give it another couple of years, and there might be something else that changes the mind of the court, and they go back a different way. So it's not set in stone. It's not 100%. Matter of fact, when Amy Coney Barrett, which I'll show you a picture of here in a little bit, she was appointed. One of the questions that kept on coming up to her was, would you change the law if regarding abortion? She kept on repeating, it was for several of the senators. It's not my job to change the law. My job is to interpret the law, whether it's legal or illegal. So that's your job to change the law. It's not to me. So if I rule this way and I find that the current law is unconstitutional, well, then you guys have to rewrite it so it's constitutional. Majority opinion is, of course, the winning opinion. So there's 1, 2, 3, 4, 5, 6 of you guys, and you 4 all vote one way. That's the majority opinion. That opinion wins. You 2 are the dissenting opinion. So you lost. You have to tell us why. So majority opinion, you guys will tell us why you think the way you think. And then dissenting opinion, the judges that don't win would give a dissenting opinion. Concurrent opinion would be if you 4, you voted for something one way because of your thought process, your opinions, and you guys voted also, but for a different reason. Right? So let's say that some of you guys, it happens to you guys probably all the time. You're going to a movie with a friend, and your friend wants to go to the movie because it's like a brand, like there's a new Spider-Man coming out. Actually, this weekend there's the Eternals are coming up for Marvel, and it's awesome. and I want to go see it because I love the Marvel universe, I love the Eternals, and I love the whole storyline. It's so cool. And you go with one of your friends, and they're like, "How? I just like, I want to go, yeah, but not for the story. I want to go because that main actor, that main actress is just so beautiful. I just want to see them on film." So you're both agreeing to go to the film, but you're going for different reasons. Or you're going to the film because I like movie popcorn. I mean, it could be I want to go on a night out. I don't care what movie we see. I just want to go. So it's agreeing, but for a different reason. All right. So this is. Did I update it? No, I did not. I have to get a new picture from my last slide to put it on here. This is the old court. It's now adjusted. Remember the court from last picture. This is the old justice that passed away literally last year, and they replaced her with Amy Coney Barrett. The Chief Justice of this court is John Roberts Jr., gentleman right in the middle. Yeah. Here is the oldest appointed justice on the Supreme Court now. It's Clarence Thomas. He was appointed back when George H.W. Bush, back in '91, during the shutdown, there was a special I found on PBS. So good about this guy. His life, at one point in his late teens, early 20s, he had joined the Black Panthers. He was an activist. He was never caught for doing anything. He did admit at some points for being involved with some stupid stuff with his friends, but nothing ever criminal. Right? So it was all property damage or things that he was involved in those sense. But then part of the video talks about how he went home and his grandpa, who raised him, essentially was so disappointed in him and basically said, "You're out of the house. I don't want you around. The way you're acting is immature." And he kind of straightened up and fixed up his path and kind of moved forward with that. But so that was the oldest appointed one. Then we have Justice Stephen G. Breyer. He was appointed under Clinton in '94. Right. Nothing really special about this guy. This is the one, sometimes in the midst of the court stuff, if you can get him on your side, you can sway the court back and forth. When Ruth Bader Ginsburg was on. But now that Amy Coney Barrett is on there, it doesn't really matter. But that's a Bill Clinton appointment. Chief Justice John Roberts was George W. Bush in 2005. The one thing, too, when you appoint the judges, lots of people look at it and go, "Oh, well, George Bush appointed him. That means he's going to be super, super conservative." He's actually come out many, many times on more of a liberal slant, where people are looking at his decisions and going, "What in the world where'd you come up with that? Well, we thought you were going to vote this way." And he's like, "No, that's not how I interpret the law." So they thought he was a judicial restraint judge, like just rule of the law. But there's been a couple of times where he's been a judicial activist and kind of interpreted the law differently and made statements where you're like, "Oh, okay, I didn't realize that." All right. One thing real quick, and this came from yesterday. One of my students was asking me about judicial restraint versus judicial activist. So I have a student in my 7th grade class. And the reason I'm looking at my rules over there is because through a series of events where I was just not aware, I'm not sure how I wasn't aware, he's been playing with his Switch during class. So I caught him though. I was like, "What are you doing?" Because he was doing the whole looking at his crotch thing. I'm like, what is in your pants that you have to look at? Like, what is going on? He's like, "Oh, I'm just playing my Switch." I was like, "What made you think that was okay?" He's like, "Well, the rules say no cell phone. It doesn't say no Switch. And I've seen you look at me while I've been playing the Switch. I just assumed you were okay with it." In my mind, it was one of those things where I was in the midst of something and I saw him, and I just didn't have time, or I just forgot. So I thought he was just on his phone. So I was like, no, you're not. No. So I went back and I looked at the rule book for the school. The school book says no electronic devices. So if we're looking at judicial restraint versus judicial activist, he was being a judicial restraint interpretation. He was looking at it and going, nope, the rule says no cell phones. I was following the rules. I didn't break any rules for your classroom. And then I said, well, since we're in government, I'm going to tell you that the school rules outweigh my rules in a federal system. Therefore, no electronic devices. But I was looking at the no cell phones and interpreting it and going, well, that includes anything electronic. And he's like, that's not what it says up there, though. So judicial restraint, the letter of the law. Judicial activist, looking at the law, interpreting the law, adding things to it. So, anyways, there's that. So he has come out sometimes, and he's been more of a judicial activist than he has been judicial restraint. Samuel Alito, he is under George W. Bush also, just a year later. Justice Sonia Sotomayor, the first Latina or Latin person on the bench. Not the first female, but the first Latin female. And Barack Obama appointed her in 2009. Okay, you guys got that one? Justice Elena Kagan, also Barack Obama appointment. That was in 2010. Her and Justice Sonia Sotomayor tend to stick together. So when one votes one way, the other votes the same way. They tend to be very, very similar in their thought process. Okay. Justice Neil Gorsuch, he was Trump's first appointment, and there was really no major issue with this guy. There's a couple questions here and there, but no controversy. He got into office or into the position relatively quickly. Justice Brett Kavanaugh. Now, this is a different story. This was in your lifetime, of course. And Donald Trump appointed this gentleman. In his court case, or his, trying to think of the phrase they use. The Senate hearings regarding this guy got heated really quickly. So right where they were about to vote, this is actually the same thing happened to Clarence Thomas years ago. Right when they were about to vote and confirm him, someone said, I'm not going to let you guys vote on this yet. I have a witness that wants to come in and speak about him. So the lady that came in, true or not true, I don't know. The problem with her story was there was no evidence to back it up. So the young lady, or older lady now, close to his age, came in and said during high school, there was a party that he was at, and he took advantage of me and my friends and basically abused us. And he came out and he was like, I am adamantly telling you that never happened. I don't know who this woman is. I don't remember her. There was never, I may have gone to parties. He's like, did I? And then one of the jokes that SNL picked up on from this guy was like, did I drink beer? Heck yeah, I drank beer. I love beer. I wish I had a beer right now. And so like SNL, of course, picked up on the whole beer thing and everything. He said it was always beer. And so the woman had her time in court, and everyone that was in favor of Kavanaugh said, okay, thank you very much. Please show us the proof of all of this. And she said, well, I don't have any proof. She's like, okay, well, then what about other witnesses that were there with you? None of them, nobody remembers this happening. So like there was, again, it may have, but there was nothing that could prove beyond a reasonable doubt that he had done anything to her. So he had it took like an additional week or so before they actually ended up voting on his approval. This is actually when he was, I'm not sure if anybody remembers seeing the pictures of it. People were pounding on the doors of the Senate chambers because they wanted to stop the vote for Kavanaugh. The irony in this one is everyone thought he was super, super conservative in his opinions of the court. He has voted probably the last 2 or 3 votes on different court cases in favor of the LGBTQ community, in favor of women's rights, in favor of all sorts of things that are typically more on the liberal side. So all the things that everyone was afraid he was going to vote against, he's actually voted for on the court hearings. So, and our most recent one, and we'll stop with this, Amy Coney Barrett, appointed in 2020 and approved in 2021 before the election was final. So she made it in. All right, next one.